suppose charge sheet is not submitted within time, then police follow another method under 473 under limitation period and demand under application extension for the investigation, and it is magistrate's discretion to allow or not to allow. After investigation, it is magistrate's discretion either to accept it or reject it. If accepted, he may try it or issue process under 204. If it is a complaint case, then otherwise it will dismiss under 203. In a police report, the trial commences in warrant case as well as police case under section 238 to 250, chapter 19, chapter 18 covers session trial 225 to 237, and summons trial starts under 251 to 259, chapter 20, and summary trial under section 260 to 265E, chapter 21, and another chapter 21A, under plea bargaining. Introduced in 2002. So under session trial, if no evidence are there, evidence are groundless, then accused is discharged under 227. Otherwise, if some charges seem to be there, then charges are framed under 228 in session trial. In warrant trial under police report 238 to 244, if charges are groundless, the accused is discharged under 239. Otherwise, charges are framed under 240. And under police, under complaint case other than police report from section 244 to 250. No charges found. Discharge under 245. Otherwise, charges are framed under 246. In summon trials, shorter one, no charges framed. And if offense is petty one, section 253, read with 206, summons served with the sentence of punishment if accused plead guilty, the magistrate acquit him. If not, then trial commences. Under 259, if the case is of severe one, magistrate anticipate punishment, term of punishment is more than 6 months, then summon case is converted into trial case. Re-examination of witnesses, same process followed in the forthcoming trial. In the case of Ghanshyam Das versus State of UP 2010, the applicant filed quashing of charge sheet under 482 in the Allahabad High Court. Charge sheet was submitted under charges of 323, 54, 504 and 506. In the meantime, the UP state government through notification published in the Extraordinary Gazette announced section 506 cognizance and non-bailable. the applicant challenged session court under 397 CRPC dismiss filed 482 in the High Court. High Court, in his previous judgment in Virendra Kumar versus State of UP, and on the basis of this judgment, held the UP state government notification unconstitutional and illegal, and allow the applicant his charge sheet be treated as complaint by the magistrate, and police officer will be as complainant. In another case, under the judgment was delivered by none other than M. Hidayatullah, Justice, as well as our Vice President later on and acting President of India, in the case of Lakshmipat versus State of Maharashtra, 1978. In this case, accused was charged under 120 BIPC. An Air India employee was also an accomplice. The applicant was charged under 120B and 1 and Section 167 Custom C Act 1878. Some gold was smuggled from abroad into India, and the Air India employee as accomplice were treated as competent witness under Section 118 Indian Evidence Act. Because of having some share of it. But under 132 Indian Evidence Act, a witness is bound to disclose his statement if it goes against him, and if the witness is to save himself, he has to give his statement against himself. But at the same time, the witness gets immunity under Article 20 subsection 3. So in this way, Justice Hidayatullah, while he was CJI, delivered his judgment. And in another case, our former Prime Minister Narasimha Rao became accused, but given him immunity under the acts of under the acts where parliamentarians were bribed to vote in the favor of or to speak in favor of their proposed bill. So this practice was caused unjustified and unconstitutional, and there where judicial review come into force. Regarding FIRs, I would like to add some cases. In TT Antony versus State of Kerala, the judgment was given that there is no second FIR. In Stinder Kaur versus NCT, State of Delhi 1992, zero FIR was allowed. Sampat Rai versus State of West Bengal, investigation by CBI was allowed. Uday Bhushan versus State of AP, Andhra Pradesh, magistrate may treat FIR not registered but forward under NCR to treat as complaint or magistrate's discretion. In Bhajan Lal versus State of Haryana 1992, Prakash Singh Badal versus State of Punjab 206, Madhu Limay versus State of Maharashtra, how to quash FIR. In Bhajan Lal case 1992, guidelines were set by the High Court of Punjab and Haryana. In quashing of FIR, Nandini Satpathy versus PL Dani 1978, it was against self-incrimination. Nandini Satpathy, ex-CM Odisha, when she was called in the police station on the charges of accumulation, unproportionate wealth, and she refused to answer DSP's queries under the gab of Article 20 subsection 3, and Supreme Court held it that if one can exercise his right to remain silent to police queries, but it does not mean that if one commit offense, very serious offense like murder, then he cannot avail this provision in his stride. He has to answer police questions. Similarly, if police ask questions under 161 or under 179 IPC, one has to answer questions. If police misuses its power, then police can be prosecuted under 166A IPC. Similarly, in Hardeep Singh versus State of Punjab 2014, an accused can be summoned only when sufficient evidence are there. Otherwise, magistrate very sparingly uses his power to summon the another accused. If he has sufficient evidence, only then he can exercise his power. Otherwise, the accused to whom summon is served, he can file appeal against the summon served in the session court. Before Hardeep Singh case, this provision was not there. So it is very important case, and under 309 CRPC, when police has authority for PS, PC and JC, under PC and JC police can ask for police custody when the accused in jail under 309 on the ground of that more evidences are needed or have come to light. Though 309 is for quick disposal of cases, and under this police custody can be asked, and from the jail, when the accused is in the jail, it is the magistrate discretion to allow or not to allow. So in our criminal jurisprudence, justice is the hallmark because if accused goes scot-free, then it is considered bad in law, and if innocent is convicted, then it is worse in law. Thank you very much.